Hello, hello, and welcome. This is Crime in Court. My name is Heather, and I am here with another episode of the Canton Cover-Up, Commonwealth versus Karen Reed, and we're still talking about Turtleboy and his indictments. We were reading through the Statement of Facts, which was a 70-page document. So we got through about 10 pages and one charge. But I went through the whole document and I crossed out any sections that were repetitive, which a lot of it was. So we're going to go through the sections that we did not cover in the last episode. But first, I wanted to sorry, I'm trying to fix everything here and I got bumped. I want to start with a little history lesson. We're going to talk about the First Amendment. So, the First Amendment: Congress shall make no law respecting an establishment of a religion or prohibiting the free exercise thereof, or, and this is the important part, abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So, you're allowed to address your grievances against a government and not be retaliated against. Canton, Norfolk District Attorney's Office. This message is for you. You're allowed to speak. It's protected speech. And I don't know how you are imprisoning a man for speaking up and asking people to tell the truth. So where I wanted to go from here is, hold on, we're going to do a little history lesson of what the common interpretation of the First Amendment is. And our source is the National Constitution Center, and they are a nonprofit organization, and they're like the leader in all things Constitution. So we're going to read the common interpretation of what the First Amendment means. So Congress shall make no law abridging the freedom of speech or of the press. What does this mean? Generally speaking, it means that the government may not jail, fine, or impose civil liberty on people or organizations based on what they say or write, except in exceptional circumstances. And I don't believe that Canton is an exceptional circumstance, that they require special attention and, being able to ignore the First Amendment for people of their town. All right, so although the First Amendment says Congress, the Supreme Court has held that speakers are protected against all government agencies and officials, federal, state, and local, and legislative, executive, or judicial. So any public figure, basically, that is an official government agency or something of that nature. So the First Amendment does not protect speakers, however, against private individuals or organizations such as private employers, private colleges, or private landowners. The First Amendment restrains only the government. So that's probably the little loophole that they think that they can get around. But because it all revolves around the Karen Reed case and the investigation of the case and the shitty job that the investigators did trying to get answers for Karen Reed and for John O'Keefe and his family. He's seeking out answers from the witnesses because the investigators didn't do it. So in my opinion, I don't think that he is, well, I don't know. It could be stated either way, that it's not protected, or it is. I guess you can make arguments either way. The Supreme Court has interpreted speech and press broadly as covering not only talking, writing, and printing, but also broadcasting using the internet and other forms of expression. So everything that Turtleboy does, he does in the name of journalism. He states it. He states he's an independent, investigative journalist. So everything that he does is protected. So there, in that paragraph, you can tell that, or you can use this to basically state that Turtleboy's language was protected. The freedom of speech applies to symbolic expression such as displaying flags, wearing armbands, burning crosses, and the like. So you're even allowed to do things like that. The Supreme Court has held that restrictions on speech because of its content, that is, when the government targets the speaker's message, generally violate the First Amendment. So, as we know, the Norfolk District Attorney's Office has a lot to lose if they let Turtleboy continue talking. But as it seems now, it doesn't matter because the feds are closing in, so they're probably going to go to jail anyways, and Turtleboy's going to be out soon. And Turtleboy actually does have a hearing this week. I can't remember what day it is, but he's got some hearing this week, and he might actually be let free. We'll see. We don't know yet. So hopefully, and fingers crossed. Okay, so laws that prohibit people from criticizing a war, opposing premature unaliving of a birth, and advocating high taxes are examples of unconstitutional content-based restrictions. Such laws are thought to be specifically problematic because they distort public debate and contradict a basic principle of self-governance, that the government cannot be trusted to decide what ideas or information the people should be allowed to hear. So, it does really appear to be that the Norfolk District Attorney's Office wants to silence Turtleboy. They've tried to confiscate his phones, his laptop, his everything, his means of communications to the outside world. They've compromised it all. And all to quiet this man. So it really makes you wonder, why did they want him quiet so badly? And they want his information, what information he has about the federal investigation. They're looking into or trying to get his communications in order, to see if he's like conspiring to something. They're trying to get him on conspiring with Karen Reed now, to intimidate witnesses. Like, no one's intimidating witnesses, people. We just want them to speak the truth. That's all. There's no intimidation happening. We just want the truth of this case, and we're not getting it from law enforcement. All right, so this paragraph stating basically, like, government should not stop people because they don't want the message heard, and I believe that's exactly what they're doing in Norfolk District Attorney's Office. All right, so there are generally 3 situations in which the government can constitutionally restrict speech under a less demanding standard. So these are the only, maybe not the only exceptions, but these are some of the exceptions to the rule. All right, so in some circumstances, the Supreme Court has held that certain types of speech are only, quote, low First Amendment value, such as defamation, false statements, and that damage a person's reputations can lead to civil liability and even to criminal punishment, especially when the speaker deliberately lied or said things that they knew were false. This would require that the state would have to prove that Turtleboy was making stuff up or saying things that he knew were false, when in fact he came with receipts for everything he said. So he's not defaming someone, and as far as I know, trying to win a defamation lawsuit is really, really difficult, if not nearly impossible. And the only reason that Johnny Depp won his defamation lawsuit was, I think, because it was televised and there was clear malingering, I would say, on the other side, at least in my views. I don't know about anybody else, but that's what I thought. All right, so that's defamation. Technically, like, any one of the witnesses in quotes, could bring a defamation lawsuit towards Turtleboy if they could prove that what he's saying is false and he's doing it falsely or, deliberately spreading false information. But they would have to prove that in their lawsuit, and that would be difficult. True threats to commit a crime, for example, I'll end you if you don't give me your money, can be punished. As far as I know, Turtleboy has never made any threats. He has said he will come back. He's said things about, not letting up in the fight to bring justice to John O'Keefe and Karen Read. And in those quotes, the state has totally misconstrued the meaning, taken things out of context, and made it seem like Turtleboy is more of a threat than he really is. He's an activist. And he says things that push people's boundaries. And that's not illegal either. So people are allowed to push other people's boundaries. That doesn't mean you try to get them for 12 counts of witness intimidation or however many counts it is now. I think it's 16 counts. All right. So fighting words, face-to-face personal insults that are likely to lead to an immediate fight are punishable. But this does not include political statements that offend others and provoke them to violence. So even if Turtleboy said, guys, this just really gets my goat, and he gets everybody riled up because he's so angry at let's just say John McCabe or something, and then everybody, like all his turtle writers, go after John McCabe. He's not liable for what he did, and because unless he said flat out, like, go over to her house and be violent to her, I mean, then that's really, he's not responsible for what his turtle writers do. So, for example, the turtle writers that are going around and taking pictures of the people who are the witnesses or suspects, and the people in town that, in the one instance when the woman was in the bar and Chris Albert was like saying nasty things to her and angry that she like took a picture of him or something, that's not on Turtleboy. Just because Turtleboy reports on something and it becomes widely known in that area, that doesn't mean that people in your area that now know information about you they're responsible for what they do. Those people in your town, not Turtleboy. He didn't make them do anything. So, for example, civil rights or anti-unaliving of babies protesters cannot be silenced merely because passersby respond violently to their speech. So no matter what Turtleboy says, even if his turtle writers do get violent with the Alberts or the McCabes, he's not at fault. Technically speaking here, according to the Constitution. Obscenity, hardcore, highly sexual, explicit, P is not protected by the First Amendment. That's not the case here. In practice, however, the government rarely prosecutes online distributors of such material. Okay, so it's illegal or not illegal, I guess, but it's not protected. Child P is obviously not protected, and I don't even need to read anything about that because it doesn't apply here, and we don't want to talk about it. All right, so commercial advertising, speech advertising a product or service is constitutionally protected, but not as much as other speech. So, for instance, the government may ban misleading commercial advertising, but it generally can't ban misleading political speech. So, all our political ads, those can lie to us. the people running for your government. They can lie to you, but manufacturers and people selling you things, they can't lie. They can't sell you misleading stuff. But politicians can. I love that. Okay. So outside these narrow categories of low value speech, most other content-based restrictions on speech are presumptively unconstitutional. Even entertainment, vulgarity, hate speech, bigoted speech about particular races, religions, sexual orientations, and the like, blasphemy, speech that offends people's religious sensibilities, and violent video games are protected by the First Amendment. The Supreme Court has generally been very reluctant to expand the list of low-value categories of speech. So even entertainment vulgarity, so the vulgar words that come out of Turtleboy's mouth, and we know he does say vulgar words, sometimes they're really funny and I laugh at them, it's protected. So even if he calls one of the McCabe's or the Alberts a really nasty word, it's protected. Just saying. All right, so the government can restrict speech under a less demanding standard when the speaker is in a special relationship to the government. For example, the speech of government employees and students in public schools can be restricted, even based on content. So that's really not the case here. Number 3, the government can also restrict speech under a less demanding standard when it does so without regard to the content or message of the speech. Content-neutral restrictions, such as restrictions on noise, blocking traffic, and large signs which can distract drivers and clutter the landscape, are generally constitutional as long as they are reasonable. So in these cases, it's still protected, but the law prohibits all demonstrations of in public parks or all leafletting on public streets that would violate the First Amendment. So neutral-based restrictions that are reasonable are that are content neutral speech that's reasonable is allowed and it's protected. Courts have not always been this protective of free speech. In the 19th century, for example, courts allowed punishment of blasphemy, and during and shortly after World War I, the Supreme Court held the speech tending to promote crime, such as speech condemning the military draft or praising anarchism, could be punished. Interesting. Moreover, it was not until 1925 that the Supreme Court held that the First Amendment limited state and local governments as well as the federal government. So they extended it to all forms of government later in the early 1900s. But starting in the 1920s, the Supreme Court began to read the First Amendment more broadly, and this trend accelerated in the 1960s. Today, the legal protection offered by the First Amendment is stronger than ever before in our history. So there you have it, Michael Morrissey. There is a lesson for you in what is protected speech and what is not. So the law that you have there that protects speech and intimidation against witnesses or whatever, talking to the witnesses, whatever your statute over there is, it's unconstitutional and should be removed from your statutes, amended in some way. I don't know. So, all right. So there you have what is generally protected, and that's good information for all of us to know. Pretty much, we can say a whole lot. Unless we're actually threatening someone or, threatening to do a crime or damage, harm to someone else, then it's not necessarily protected. Even, it's still protected, but threats are a little different. All right, so anyways, let's move on. The fight for free speech. And this, my friends, I believe is also our fight. So when just one person fights for their right to speech, they are fighting for everyone's right to free speech. Turtleboy's fight is also our fight. And he's fighting for all of us. He currently is sitting in prison on some bogus charges, which we'll get into another time. But He's sitting in prison on some bogus charges because the state really wanted him to be quiet. The state of Massachusetts, Commonwealth of Massachusetts, is corrupt. At least Norfolk County is. So, to quiet him, they made some kind of elaborate scheme with one of his ex-girlfriends who invited him over. They made her a witness so that it became witness intimidation just by him, talking to her or whatever. And they got into a fight. She was fighting with him. He recorded portions of it and put it on his YouTube page. And all it is her yelling at him. So I don't know where him being violent in any way or, screaming, that didn't happen. Nothing along those lines. It sounded like she was the one that was being irrational and out of control with her emotions. He seemed calm and wanted to leave, and she wouldn't let him. So eventually he did get to leave. He got into a car accident because he was so tired from staying up all night with her. She wouldn't let him leave, and from fighting with her. He fell asleep while driving home, got into a car accident, and then is told that he has a be on the lookout and whatever for his arrest because they were going to charge him with DV and assault and battery and other things. So anyways, that's kind of the recap of where he is, why he's in prison now. And he could plead out. He could be out at any time. He could leave on his own recognizance right now if he admitted and pled guilty to the charges that he was violent with his ex. But it's not true, and he's not going to. So he has been sitting in prison for almost 40 days now, or just around 40 days now. And it's been nuts. Like, I can't even believe that they have allowed this far. Anyways. So we're going to talk about, we're going to go back to that statement of facts, which was this big, long 70-page document. And I highlighted everything here. So the first thing that we read last time, this was intimidation of a witness. We read through all of this. Remember, these were all the people that were in attendance that night, including Colin Albert was there. And then they asked for all of their information. This is like a background of who Carney is, Aiden Carney, and then some quotes that they took out of context. And so we read through all of that. This one was a voicemail that he left to Trooper Proctor because this particular charge, if you go down, we read through all of this already. It was witness interference with Michael Proctor and Elizabeth Proctor. So I went through and I just highlighted like what each of the charges are one by one. So intimidation of a witness, Elizabeth and Michael Proctor. And Elizabeth is on there because he ran her plate or something. I don't even know. Like he wasn't, I don't know. Oh, did he leave her a voicemail too? He might have. And she didn't like it. And this time, remember, I found a better picture of that for you. This is Jen McCabe's car at Proctor's house. And one of those two cars are Elizabeth and Michael's cars. So I guess because he took a picture, or somebody, it wasn't even Aiden, somebody who drove by and saw Jen McCabe's car there, snapped a picture and sent it to Aiden. And then they found out who the license plates belonged to, and it was Matt McCabe. Was that Jeep sitting outside, I think. And then the other two belonged to Michael and Elizabeth Proctor. So that was the first charge. Now we're going to move on to the second charge, which is intimidation of a witness and picketing a witness of Juliana Nagel. So remember, Nagel is the friend of Brian Albert Jr. We're going to skip down. Sorry. Let's go. Okay. So all of this is the same. It's all repetitive. We've gone through all of this already. He takes many of the same quotes. But here's the rolling road rally. And we talked about this a little bit last time, I think. Sorry, my screen's fallen. So we talked about this a little bit last time, was that Aiden, I don't know if he actually organized it, but it does say he organized and publicized. He definitely publicized this rolling road rally. It was a very peaceful protest. People got in their cars, drove from place to place that they were protesting, like different homes or places, and they'd get out, hold up their signs for a little bit, and then go peacefully. It was like a very peaceful day. I remember watching it on his stream the day that it happened. So here's what the Commonwealth says about that rolling rally. Carney organized and publicized a rolling road rally where protesters would travel to the homes of witnesses involved in Commonwealth versus Reed. On Saturday, July 22nd, 2023, at approximately 1200 hours, Carney departed Shaw's 134 Nahanen Street, in Norwood, accompanied by a number of motor vehicles. Carney began a YouTube live video. YouTube Live allows users to broadcast live videos on the YouTube platform, which can be later saved and distributed on a user's account. At the beginning of the video, Carney is operating a motor vehicle and stated at least 200 people are in the caravan of vehicles. He further stated he did not broadcast the locations of the protest prior to the departure of the rolling rally. So he was being responsible by not protesting the addresses. So I don't know what is illegal about this. Nothing. Remember we have a right to peacefully assemble. The right of people to peacefully assemble. Morrissey. During the video, Carney stated the purpose of the rally is to protest an unaliving, cover-up, and framing of an innocent woman. He stated some witnesses will be in jail within a year and brags about being able to locate the witnesses wherever they travel. During the duration of the rally, he thanked the other members of rally for attending. So, all right. So Juliana Nagel, age 25, lives at, we're just going to dox her. You get mad at, you tell Aiden that he's doxing, Michael Proctor and giving out his business cell phone number, his work number. And then here you just put people's addresses out on blast. You don't redact them. And I wasn't going to, because I want to prove a point that the Commonwealth just blasts out people's addresses. All right, so Juliana Nagel, age 25, lives at blah, blah, blah Street, Canton, with her 2 parents and 2 siblings. Juliana was home with her mother at the time of the protest. Juliana and her brother Ryan Nagel were present at 34 Fairview Road and had been interviewed by investigators. When Carney arrived at 78 Highland Street, he identified the residence as the home of Juliana Nagel. Carney made a statement to get the attention of the neighbors of Highland Street. He described how O'Keefe was beaten to death at a house where Juliana Nagel was present. He stated, quote, "At any point, Julie Nagel, you can come out at any point, Julie. Nothing is stopping you from telling the truth. You know what happened that night." He continued, you can't get away with it anymore. Too many people know. You are going down with them. Nothing is stopping you from coming forward and telling the police what happened. Carney claims Nagel lied to investigators about her observations the night that O'Keefe was unalived and is complicit in the cover-up of his unaliving. So, I don't understand what's wrong with that. He's urging her to come out and tell the truth. So, that's protected speech right there. I don't know what the district attorney's office is doing. All right, so Carney stated, "You might as well tell the truth and let the world know what happened. Neighbors, maybe you guys can help us pressure them into this. Julie Nagel was involved, was at the unaliving of a Boston police officer. She knows what happened, and she is actively involved in the cover-up. She should not be able to walk around town like none of this happened while an innocent woman named Karen Reed suffers the consequences of her silence and her complicity. The truth will set you free. Carney is in front of the residence for approximately 10 minutes. At the conclusion of the speech, he stated the next location is the home of Canton Police Department Deputy Chief, that's a long title, Thomas Kelleher. While traveling to the next location, Carney stated Julie Nagel's house was a good one. They were home. So, none of this is unconstitutional. All of it is protected speech. And he's doing it in the form of activism with a bullhorn and people assembled. He is allowed to say everything there that he said. During recorded interviews on the YouTube account Risflex, dated August 20th, 2023, Carney made comments about his influence on the jury pool. I want the world to know what happened here. They want the story to be silent. Nobody knows about it. They want to be able to find a jury pool that has never heard of any of this shit before so they can manipulate them. And same way they have manipulated everyone else, and I'm not allowing them to do that. Happy to do it. Okay? Because he wants people to know about this case. Therefore, that's jury tampering or witness tamper. I don't know what they're trying to get at. Based upon the foregoing facts, there is probable cause to believe that Aidan Carney committed a violation of Massachusetts General Laws, Chapter 268, Section 13B, witness interference of Juliana Nagel. And I'm not going to read all this because it's all the same. We read through all of this before, but we do know, I will recap that each count could be 10 to 20 years in prison and a fine of $1,000 to $10,000 each, and imprisonment possibly. So based on the foregoing facts, there's probable cause to believe that Aidan Carney committed the violation of Massachusetts General Laws, Chapter 268, Section 13A, picketing a witness. So this is also picketing. Didn't highlight that, which reads, whoever with the intent of interfering with, obstructing, or impeding an administration of justice, or with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty, pickets or parades in or near a building housing a court of the Commonwealth, or in or near a building of residence occupied or used by such judge, juror, witness, or court officer shall be punished by a fine of not more than $5,000 or by punishment for not more than 1 year, or both. So that's what they're trying to get on picketing of a witness, which is also not constitutionally protected. This law itself is unconstitutional. To have a specific set of people be protected from other people picketing or trying to assert their political beliefs or whatever beliefs. Yeah, it doesn't make sense for this statute to even exist, or this law. So given the continuing harassment of witness for the unaliving of John O'Keefe, I respectfully request an arrest warrant to be issued. Brian Tully. It's always Tully. So that was for Juliana Nagel, the witness, intimidation of a witness and picketing of a witness, Juliana Nagel. Next is Julie Albert. So that is Chris Albert's wife. Julie, this is, she actually went home, so she wasn't even there the night of. She's not even a witness, so I don't know why she would be on here. But intimidation of a witness, it says Christopher Albert, but it's for Julie Albert, which is Christopher's wife. So we'll skip down to where all that other stuff is stuff we already read last time. So since April 2023, Carney traveled to Canton on several occasions. On one occasion, Carney went to D&E Pizza, which is owned by Chris Albert. Chris Albert and his wife, Juliana Albert, were with John O'Keefe and Karen Reed prior to the homicide. Chris has been interviewed by investigators. During the visit, why not Julie? During the visit to D&E Pizza, because she's not a witness, Carney confronted Chris. Carney later stated on a video post on YouTube for his followers to confront Chris Albert, order food from D&E Pizza with the intent of not paying for the food, and harass. I don't remember him ever saying that. I believe that this is a straight up lie, that the Commonwealth is lying, because I don't remember him ever saying that. Chris Albert stated he has had a vast increase in the number of telephone orders not picked up or paid for since Carney made those statements on the YouTube video. Carney has made additional trips to D&E Pizza where he held signs and confronted people in and around the restaurant. Again, he has a right to do that. Public property, he can stand on a public street and protest. Doesn't matter that Chris is a witness in the case. In July 2023, Carney posted a blog on his website regarding Chris Albert. The blog contains a video where Chris was confronted by a follower of Carney's outside a Canton restaurant, also referenced above. So that was the one with the lady who recognized him and I guess was taking pictures, and he got mad. So he said in his blog post, "Let's keep it up. I was so proud to see Turtle writers unafraid confronting evil like this in the flesh. The fact that he's still going to places like the Waterfall Canton restaurant is better. He feels comfortable doing so. It's because he feels comfortable doing so. But people who unalive other people and those who cover for them do not deserve a life to live a comfortable life while Karen Reed suffers and fights for justice for John O'Keefe." Again, that's his belief. That's a political belief. That's definitely protected speech. I don't know. Commonwealth, you're going to be screwed when this goes to the Supreme Court. On June 13th, 2023, Carney broadcasted a live YouTube video, which is currently posted on his YouTube page. During the broadcast, at the 35-minute mark, Carney displayed call detail records of Jennifer McCabe from the day O'Keefe was unalived, which included phone numbers and names associated with the phone number. So you're complaining that he's doxing people when you've put everybody's home address in here and phone numbers too. Didn't redact a damn thing. But it's okay. It's not okay for Aiden to do it. Got it. Okay. So the records had previously been attached to a defense motion filed in Commonwealth versus Reed. So it was a public document and it was there. It wasn't redacted. So he read it on his stream. I don't think that's illegal. So I don't know. Carney called Juliana Albert, Chris Albert's wife, and left a voicemail message. Juliana stated a person claiming to be Carney called from phone number whatever. Carney left the following voicemail. "Hi Julie, this is award-winning journalist Aiden Carney calling from Turtleboy Daily News. Just calling to ask you a few questions, that's all. At the board select meeting a few weeks ago, you looked great and extremely happy in the front row and extremely comfortable that you wanted to be there. So I just want to ask you just a couple of questions. I'm reading a police report right now from February 10th, 2022, which Michael Proctor says he interviewed you and introduced himself for the first time, which confuses me a little bit because it seems that your family has known him for quite some time." Interesting. "I was wondering how your son Colin, who was at 34 Fairview Road the night that John O'Keefe was unalived, ended up in a wedding party with Trooper Proctor and Trooper Proctor's sister before he was actually a trooper. And I wanted to know, who did you guys meet, and did you guys just forget about each other over time that you had to be reintroduced again? But what I'd really like to know is if you were in the Canton High School class of 94, how the hell did Jen McCabe win Best Looking? Were they using Dominion voting machines? I don't know. How did that happen, and how does that hurt your self-esteem to know that you were in the same graduating class as Jennifer McCabe and she got Best Looking? How do you cope with that? Do you need therapy? That has to hurt your feelings, right? Because that would just devastate me if I lost a horse. I lost to a horse face. I'm sorry. I don't like to make fun of people, and I don't do it, and I won't do it on my channel, but I think it's quite funny here. All right, so give me a call back when you got this, and we'll talk soon. Bye. Again, none of that, like, he didn't threaten. He didn't say anything awful. I don't understand why I like here the footnote. YouTube is a free video sharing website that allows users to upload and view online videos. Like, the court doesn't know that. I don't know. Okay. Moving on to Chris Albert stated he received a phone call from the number ending 6909 on June 19th, 2023. Albert did not answer the call. The following voicemail was left. Yes, Chicken Parm Charlie. That's what Aiden calls him because he's got the pizza shop, but I'm not sure where the chicken parm came from, but they all call him Chicken Parm Charlie. So this is award-winning journalist Aiden Carney calling you back. You messaged me on the night of April 17th when I first wrote the story about your son being involved in the unaliving of John O'Keefe. You said it was unfortunate that I was going to write about that. I have not heard back from you yet, so I am still following up on that. I'd also like to know about a report that I'm reading right now in which Trooper Proctor claims that he was formally introduced to you on February 10th, 2022. Remember, we read that, and I even was like, they introduced each other they introduced themselves to one another. I thought that was weird because I was like, Trooper Proctor knows everybody here. And of course, I lost my place. I'd also like to know about a report that I'm reading about Trooper Proctor. I'm a little confused by that because we have pictures of your family with Trooper Proctor dating back as far as I believe 2011, if not further. So did you guys both have amnesia that day that you needed to be formally introduced? Do you often need to be introduced to the people that you have known for a long time? Do you live perpetually in Groundhog Day? I know this was right around Groundhog Day when this happened, so maybe it just kept replaying and you got to do it all over again the next day. I don't know. I'd like to learn more about this. So if you get back to me, that would be great. And also, I'll take 2 blackened chicken parms, extra mozzarella, and we'll see you soon. All right. Again, all protected speech. So, I don't know. He's asking questions. I mean, he makes it funny. He puts the spin on it with the funny stuff, but he really is asking like hard-hitting questions that we want to know. Like what's going on with Albert or with Colin? Like, why was he in the house? Or, what was going, I don't know. When did he leave exactly? We still don't know or have an exact time when he left the Albert house. All right, so on October 2nd, 2023, Carney posted a video on YouTube where he reads from an affidavit in support of a harassment prevention order filed in Stoughton District Court by Chris Albert. So Chris Albert tried to get a restraining order or protective order, whatever it is, in Massachusetts. He tried to get that for Aiden so that Aiden couldn't talk about him on his show or whatever. At the 6-hour and 10-minute mark, Carney stated, "You, Chris Albert, don't have the right to live peacefully, dude. It's not a thing." All right. And in that, I'm sure he, in his context, he was talking about having to answer to these questions. You're not going to live peacefully until you start, making the night make sense to us, because the investigation right now doesn't make sense. So you don't deserve peace until Karen and John and his family get peace. So I get where he's coming from. Like, I believe, I know his intent isn't like, I'm coming after you 24/7 and you better be scared. He's never once done that. He's never threatened them outright. And he's even offered to like have them on his show. He's offered to, confront them in person, and no one will take him up on it. So they just want to do a restraining order, which got denied, which was pretty funny. So restraining orders on, I think Colin Albert, Jen McCabe, I guess Chris Albert, and maybe Brian. I don't know if there were more than that, but they all tried to get restraining orders. And the court denied it because everything he was doing was under free speech. But then they came up with this bullshit document. All right, so based on the foregoing facts, there is probable cause to believe that Aiden Carney committed a violation of whatever law, Chapter 268, witness interference. Again, Juliana Albert. I'm not going to read it again. So given the continuing harassment of witness for the unaliving of John O'Keefe, I respectfully request an arrest warrant be made. So that was Julie Albert, intimidation of a witness. That was the third charge on this document, the statement of facts. So moving on to the next one. This is intimidation of a witness, Chris Albert. So it's basically the same exact thing as above, but it's for Chris. Let's see if they have any different content here. That was for Julie and Chris's statement. So they were both combined, but they put it on here twice because they're two different people. So that was Chris. What's the next one? All right, so intimidation of a witness was Chris Albert. The next one's going to be picketing of a witness for Michael Proctor. Intimidation of a witness, picketing of a witness. Scrolling through all of this, it's repetitive. It's all the text we've read before in the episode 12, part 1. That's where we went over all the stuff that I've already crossed out. On June 13th, 2023, Carney broadcast a live YouTube video, which is currently posted on his YouTube page. During the broadcast, Carney displayed phone records of Jen McCabe from the day O'Keefe was unalived. The record displayed names next to the phone number, which appears to be the user of the other phone number. These records had previously been an attachment to an unredacted defense motion filed in the Commonwealth versus Reed. During the video broadcast, Carney cold calls the phone numbers without names associated, and he didn't know who he was calling. So he would just randomly leave messages for people. In the process, Carney called a work cell phone of Trooper Proctor. Again, it's his work cell phone, and he's mad that that got blasted on the internet. Trooper Proctor stated the phone number that made the call was from ending in 6909. Carney left the following voicemail. And I believe we read through this too, didn't we? I don't know if we did. I thought it might have been on the first one, but let's read it anyways. Oh no, we did. We did read this. Sorry. Okay. So we read that already. As a result of the cell phone number being broadcasted, Trooper Proctor began to receive random and harassing text messages and voicemails. In the 12 hours following Carney's calls, Trooper Proctor received approximately a dozen text messages, phone calls, and voicemails. Again, I'll have you know it's a dozen. Okay, a dozen combined text messages, phone calls, and voicemails. So what? Don't answer your phone. Ignore it. Block it. Whatever. The content of the calls and messages pertain to Trooper Proctor's alleged involvement in the conspiracy and called for his termination. People have a right to be angry. He's a public figure. Trooper Proctor had to change his work cell phone number, poor Proctor, to avoid the constant unwanted calls and messages. I mean, I get it. I wouldn't want my number on blast either, but it was a work number and there weren't that many. You can deal with it like a big boy. Michael Proctor is married to Elizabeth Proctor beginning in April 2023. Carney wrote blog posts about Elizabeth Proctor. On May 9th, 2023, Carney authored a post about Elizabeth. A video is attached to the post. The video depicts a cell phone screen of an Apple iPhone. The user of the cell phone dials the cell phone number of Elizabeth, which is displayed on the screen. Carney further writes, I can think of two people who deserve to lose their jobs over this alleged conspiracy against Reed, though. Michael Proctor and Elizabeth Proctor, those two lowlives, think they are untouchable. They're nothing but bullies who terrorized people for years, but now they've met their match. And this was actually in response to Elizabeth Proctor and I think it was someone else that we haven't talked about, who also was trying to get people fired. They were calling up and trying to get people fired from their jobs. So this is Aiden giving her a taste of her own medicine, I guess. I don't know. All protected speech. At this point, I mean, I don't see anything different here. All right, so in the post, Carney states Elizabeth works as a human resources manager. I know we read through a lot of this. Yeah, we did. I believe we read through that. So much of this is, the Turtleboy effect. And then this is more road rally stuff. But we got to get to where he talks about, the second location here. The second location, the rally where the rally stopped was the second location, the rally where the rally. This is so poorly written. The second location that the rally stopped at was the home of the Proctors. Michael and Elizabeth Proctor live at 6 Wentworth Road with their 2 young children. Michael and Elizabeth Proctor were not working on that Sunday. The Proctors purposely vacated their home and made plans in order to avoid the protest. So they knew about it. So they had fair warning and they left their home. They weren't, I mean, they could have stayed home. It wasn't like anybody was going to confront them. Whatever. Anyways, so the Proctors purposely vacated their home and made plans in order to avoid the protest. When Carney arrived at 6 Wentworth Road, Carney continued to use the megaphone and stated Trooper Proctor has framed Karen Reed and stated personal information about Trooper Proctor's family. Carney described Trooper Proctor as the most pivotal in the cover-up. While in front of the Trooper Proctor residence, Carney described how Trooper Proctor allegedly participated in framing Karen Reed for the purpose of covering for other police officers, planted evidence, and called him a disgrace. All of those things are protected speech. I'm sorry, but they are. He can say all those things. He can think all those things. During the speech, Carney continually pointed to the residence. While in front of the home, members of the protest walked on the lawn of Proctor's residence and spit on his driveway. That, I don't know if that happened either, because I remember him saying, like, everybody stayed in the street. It was all respectful. Nobody walked on lawns. And if we don't have a picture of somebody or video of someone spitting on a lawn, then I don't know if it happened. So, again, this might be like a flat out lie that they made up, because I remember Carney saying like everyone was being peaceful and staying in the streets and not getting on private property. So I don't know. While in front of the home, members of the protest walked on the lawn, spit on his driveway. Carney recorded statements at his location that were approximately 7 minutes long. Shortly after the speech, Carney admitted that he did not attempt to obtain a permit authorizing his protest for blocking streets. At the conclusion of the speech, Carney stated the next location will be the home of Matthew and Jennifer McCabe. Shortly after entering his vehicle, Carney stated the purpose of the protest is to get justice for John O'Keefe and justice for Karen Reed. That is what we are here to do. So he's stating right there, this is political. This is advocacy for justice, for the injustices that he's seeing that are happening. That is what he is protesting about. in government. This is a picture. It's really hard to tell, but you can kind of see like people standing around and there's cars. It's a terrible picture, but it's a picture of them, a still photo of the video from the Proctor's house. So Carney recorded statements shortly after. At the conclusion of the speech, Carney stated the next location will be the home of Matt McKee and Jem McCabe, and they're here for justice. All right, so in the days leading up to July 22nd, cameras were placed outside of several of the locations where the protest was scheduled to occur. Below is a still photo. Okay, so they're not doing anything wrong. During the drive to the police station, Carney stated the family members of John O'Keefe should believe Karen Reed is not responsible for the unaliving of John, and how much slack are we supposed to give you to the John O'Keefe family, the time period for the grief, whatever that we are giving you. Like, we are not going after you because of the grief that is expired. It's expired because you're trying to send an innocent woman to jail for the rest of her life. I don't feel bad for you anymore. Carney later remarked he was planning on protesting outside of the home of former Canton Police Chief Kenneth Berkowitz, but was unsure if he had moved from a specific address. Carney stated, I don't want to take the chance that he doesn't live there anymore. I don't want to bother innocent people. That's responsible of him. I don't understand why that is like being used against him as ammo. Like, that's showing that he's responsible. He's like, I want to protest Chief Berkowitz, but I'm not sure if it's his house, so I'm not going to go there because I don't want to protest for no reason in a house to a bunch of strangers. And cause, people to look, because that's what the protests did. It caused people to come out of their houses or come to the windows and, see what was going on. It required people to understand that something bigger was happening, and to be aware of their circumstances or the people around them. Anyways, all right, so we read that about the jury pool. A Facebook account on September 25th, a Facebook account believed to be used by Carney, Clarence Woods Emerson was the name, posted the following message: anyone in Canton want to take a couple pictures for me? So we read all that. That was the Jeep in the Jeep photo of what's her face, Jem McCabe's car at the Proctors. They ran the plate, so we read all of this. I don't know why I didn't cross that out. So this was witness interference for Michael Proctor and Elizabeth Proctor. Those are the charges here. And picketing Michael Proctor. So that's on there. The next one. Uh-oh, my thing stopped. Timer stopped it. Okay. Sorry, my essential oil diffuser there behind me. Oh, it must be out of water. Never mind. All right, so the next charge, we did Michael Proctor. The next charge should be intimidation of a witness, Colin Albert. So Colin Albert, intimidation of a witness. We read through all of this. It's not new. None of this is new. Here it's new. On July 26, 2023, Sergeant Yuri Buchanan of the Massachusetts State Police, Norfolk, whatever unit, interviewed Colin Albert regarding harassment he has received from Carney and his followers. Colin Albert is the son of Chris and Juliana Albert and was 17 years of age on the day O'Keefe was unalived. On April 17, 2023, Carney posted on Twitter a statement alleging Colin Albert is responsible for the unaliving of John O'Keefe, specifically stating Colin and O'Keefe were in a fist fight at 34 Fairview Road. That's a theory. That's his theory. That's okay that he says that. His alleged propensity for violence. Oh, yeah. So since that post, Carney authored several additional posts about Colin, his alleged propensity for violence, and personal information, including where Colin will be attending college. And eventually Colin dropped out. Since that time, Colin has been the target of harassment and intimidation on social media. Employees of his college, Bridgewater State University, has received emails from people who copied Carney's false allegations. Again, he's not responsible for what watchers do, for what his viewers do. On July 8th, 2023, Carney broadcast a live YouTube video. During the broadcast at 2 minutes and 23 seconds, Carney stated he has Colin Albert's cell phone number. He stated he is going to call it and hopes the effer answers. In the video, Carney places the call via a cell phone while utilizing the speaker. The phone call goes to voicemail. The greeting of the voicemail states the number of the person Carney is calling, Colin Albert, which is broadcast on the YouTube video. Well, it's okay because you blast everybody's information here. Right, District Attorney? Right, Brian Tully? Yo, Colin, it's Turtleboy from the Advantage Boys. So there was some voicemail or something. I can't remember. I don't know what it was for, but there was some voicemail where Colin was acting like a total tool and talking this way, like, yo, 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 what's up? I'm here with my boys or whatever. Bang, bang, bang. So Aiden was actually mimicking that recording of Colin that's out there. So the first part of this is really he's making fun of that message that Colin left in a previous whatever. I don't know what it was for. So, yo, Colin, it's Turtleboy from them Advantage Boys. Bang, bang, bang. He even did it in like that voice, like making fun of him. So, yo, we'll F any of you dogs up. Yo, you challenge my boys, them Advantage Boys, to a fight, dog. And we about that life, son. We ain't that life. And we from Sharon, son. Are we about that life? Yo, y'all Canton bitches ain't hot, yo. Us Sharon bitches are Advantage Boys. Nothing be effing with us and shit, dog. You call me back. And then he goes back to normal. He's like, no, but seriously, it's Aiden Carney from Turtleboy. I just want to know, were you the one who unalived John O'Keefe, or was that your Uncle Brian? Who hit him first? Who hit him in the back of the head with the thing? Are you worried about or that you're going to go to jail for the rest of your life and that you won't be able to play football at Bridgewater State next year? I'd love to have a conversation with you. Your dad kicked me out of your pizza shack and I didn't get to eat his mediocre chicken parm. So I just wanted to know if you could talk to me about that, and maybe you and I could go for a ride. We could find them Advantage Boys. Bang, bang, bang. I don't know, so give me a call when you get this. Bye. Clearly, he was joking with him about that in the language in the beginning, and that was obviously Colin that he was mimicking. So, I don't know. Whatever. It's still not a threat and still totally protected. Colin stated to Sergeant Buchanan that the intimidation he has received from Carney has made him sad, scared, and paranoid. He fears physical harm from strangers. Colin attended Bridgewater State University, where he was a member of the football team. Colin was enrolled to return in the fall of 2023. Due to the past harassment and the threat of future harassment, Colin chose to withdraw from the university football team. Show us the threats. Show us... I don't know. I don't know. Turtleboy's not making threats. He just wants the truth. He's trying to get to the truth. So on September 24th, 2023, Carney broadcast a live YouTube video At the 2 hour and 31 mark, Carney is talking about an interaction he had with Jillian Daniels, Colin's aunt. Okay, so that's who Jill Daniels is the aunt of Colin. While describing their interactions, Carney stated, I'm trying to put her, like, godson nephew in jail and, you know, kind of like destroy their life. He can say that. It's not a threat. I mean, it isn't a threat. He says he's trying to do it. He says, you know, I'm sure there was more context to that, and there was probably talk about, you know, the fact that Colin might be guilty of a crime. I don't know. So based upon the foregoing facts, there is probable cause to believe that Aiden Carney committed the violation of Chapter 268, Section 13B, witness interference with Colin, which I'm not going to read. So we're at now we're moving on from Colin to, we're getting there, John McCabe and Elizabeth Proctor, and this is for conspiracy to commit intimidation of a witness. So this is a little bit different. Now we've got conspiracy, so we're just piling on the charges here. I don't know what his conspiracy is, but let's find out what Brian Tully thinks conspiracy is. So all of this is background. We've been through that. We've been through all of this. Remember, Brian Tully, this is his affidavit. So he's saying, I interviewed Jen McCabe regarding the incident. She stated she had never met Elizabeth Proctor or Michael Proctor prior to September 23rd, and they started bonding over the harassment and intimidation that they've been facing, and it's made them bond and share throughout the process, is what the claim is from these two about having known each other prior to this case. They claim they did not. All right, so all of that, this is because he asked to get the license plates, which we've already covered up in the top portion, but that was for Elizabeth, intimidation of Elizabeth. So now this is conspiracy of Elizabeth and Jen because he ran their license plates or something. He got someone to run the license plates to ensure that we were correct in thinking that it was Jen McCabe's car sitting outside of Elizabeth Proctor's home. So because he wanted to find that information out, that's conspiracy to commit intimidation of a witness, apparently, for Jen and Elizabeth. So that's 2 charges. This is ridiculous, guys. Is it not? I'm still going. Okay, so Matt McCabe and Jen McCabe, intimidation of a witness and picketing of a witness. So these are both like identical. Again, they just did one. They did it twice, probably one for Chris and one for Brian, one for. Wait, who are we on? Here. All right, Jen McCabe. Carney has targeted Jennifer and Matt McCabe with many harassing and intimidating statements and acts. The McCabes were with O'Keefe and Reed in the hours leading up to O'Keefe's unaliving and were present at 34 Fairview Road in Canton. Reed's defense attorneys have alleged the McCabes have lied to investigators and have conspired with other witnesses to frame Reed for the unaliving. Carney has confronted and harassed the McCabes as a result. Asking them questions isn't harassing them. And it's only harassment if you don't want to answer them because you're hiding something, apparently. All right, so on June 6th, 2023, the McCabes traveled from their residence in Canton to Billerica to attend a sporting event where their children were participating. Carney learned the McCabes would be in Billerica. Carney, whose MA driver's license has an address of, oh, good, so they just blasted him, traveled to Billerica, confronted the McCabes, and posted videos of the interaction online. It was quite funny, actually. He went up and started asking them questions in the bleachers, and they did not like it. And they started pushing him around. Carney would later write a blog post about the interaction where he stated Jen and Matt McCabe do not deserve to live a normal life and pretend that they weren't involved in unaliving a Boston police officer. Again, he's writing this. He is press. He is a journalist. He is writing all of this is in the name of journalism and justice. So I don't understand why, or even how he got these charges against him. I don't know how this got approved and signed and whatnot. On June 6th, we read that. While the McCabes were seated in the stands, Carney approached Jennifer McCabe and asked her repeated questions about the alleged conspiracy. Matthew McCabe attempted to step between Carney and Jen in an effort to prevent Carney from videotaping Jen. On a subsequent YouTube video, Carney bragged about the confrontation. I went to her kids' lacrosse game and made a scene there and got kicked out because I kept calling her a cop ender. Again, free speech. It's allowed. He's not, if anything, like, they should be filing their own, like, harassment civil suit against Turtleboy, and this never should have been something signed off by a judge like this, from the Commonwealth. On June 26, 2023, Carney traveled to the home of Matthew McCabe and Jennifer McCabe at 12, whatever. Carney video recorded his arrival at the residence and later discussed the trip to the residence in a YouTube video. Turtleboy returns to Canton. In the YouTube video, 30-minute mark, Carney stated when he arrived, he noticed the front door to the residence was open. He stated, well, the open door will make this easier. She can't close on me. Carney played the video he recorded at the residence of the YouTube video. Carney rang the doorbell and video recorded the interior of the residence through a glass storm door. Protected. He whatever you say, Jen, it's not, whatever. A person is seen inside the home of Carney's video, which Carney stated is Jen McCabe. Carney, who was videotaping into the home for approximately 1 minute. Yeah, 1 minute. And then she never came to the door and played like she wasn't there. And he left. So it wasn't a big deal. And he did that once. I don't know, it's not like he was doing that over and over again. That would be harassment. One time is not harassment. Sergeant Buchanan interviewed Jen McCabe on July 24th, 2023 regarding the harassment and intimidation. Jennifer became upset and stated she is concerned for her safety and well-being of her juvenile children. She stated her children are upset, embarrassed, and angry at the false accusations Carney has been broadcasting. She stated the children are afraid to be at their own home. Jennifer later told Sergeant Buchanan that Carney repeatedly keeps showing the pictures of Trooper Proctor at a cookout and misidentifies children in the photo as her children. So she's trying to deny her own kids. She stated Carney has shown one of her children at her first communion and family photos. Jennifer stated her 15-year-old daughter is being recognized and photographed in public, which terrifies her daughter. That I don't like, but there's nothing illegal there. On September 20th, 2023, Carney broadcast a live YouTube video. During the video, Carney repeatedly stated that Jen McCabe ended John O'Keefe at the 1 minute 54 mark. In the video, Carney stated, I am saying this as a matter of fact that Jen O'Keefe participated in unaliving and planning to unalive and cover up the unaliving of John O'Keefe. I am saying that. This is not my opinion. Later in the video, Carney displayed a sign on the lawn of Jennifer McCabe's sister in Canton that states, you killed John O'Keefe, you worthless piles of shit, and I'm going to find you, MFer. I'm going to find you. You just know that you want to effing dance. We can effing dance. I didn't know who you were before this. I thought you were Jen's lesbian sister and some shit. I didn't know some shit about you. Now we know all about your son, Tommy. Tommy's the lacrosse coach. I believe, at Canton High School, right? Yeah, whoa. We can talk about Tommy too. We can pay Tommy a visit too. We're going to go after, you're going to get the whole effing deal now. All of it. Allie McCabe, she can get it too. I don't know. I don't know what this is all in reference to, but I believe it's all taken out of context. They can all get you. We have left the second generation out of this for a bit, but that's over, except for Brian Albert Jr. because he looks functionally ard. I'm not going to say that word. But besides him, the rest of them, they are going to get it. They're all going to get it. Caitlin Albert, we've got some questions for you. Show up at another Bridgewater State football game. I dare you. Daddy is coming to town. These people make me sick. Again, I don't see... Like, I can see them saying, like, you want to dance? We can dance. But, and I'm going to get you MFer. But if you listen to the rest of his videos, the context, he's all trying to state that he wants them to tell the truth. By getting them, he means getting them to tell the truth and to come forward with what actually happened that night instead of the lies that we've been told so far. So everything that he's saying here is in relation to getting to the truth of the matter of this case. It's not about, violence or something like that. So I don't know. We're going to skip all this because we talked about the rolling road rally. It's hard to say. The third location of the rally was the home of Matthew and Jennifer McCabe, where they live with their 4 children. Ooh, they got 4 kids. Both Matthew and Jennifer were with O'Keefe in the hours leading up to his homicide, received a phone call from Reed in the early morning hours of January 29th, and Jennifer was with Reed when O'Keefe was found unresponsive. During the rally, Matthew, Jennifer, and 2 of their children were home. Prior to the rally, Carney posted pictures of the McCabes on vacation and made statements that he, Carney, can find the McCabes wherever they travel. When Carney arrived at their residence, Carney exited his vehicle and walked to a camera attached to a mailbox of the residence. He stated he knows where she currently is located and stated no justice, no peace. Carney stated that the residents of the home are the McCabe family. Carney made statements that Jennifer McCabe is going to jail and, quote, she doesn't give a shit about her kids. Her kids need to see their mom in jail because the cycle will repeat itself, end quote. Again, free speech. I mean, you might not like what he's saying. It might offend people, but it's free speech. The person specifically that he's saying it about, I'm sure offends that person, but it's free speech. You can say that about someone and not be put in jail for it. All right, so Carney then spent several minutes claiming how Jennifer McCabe participated in unaliving by failing to save John O'Keefe's life, manufactured evidence in the form of phone call to John O'Keefe, made allegations of Jennifer McCabe's actions after the fact, lied to Karen Reed, and misled investigators. Very, very, very good points, because she did all of those things to help cover. And they all knowingly left him out there to let the cold end him so that they weren't the ones that ended him specifically. So even though they caused his injuries that contributed to his end. So where do we go? So Carney spent several minutes claiming how Jennifer McCabe participated in the unalivings. Carney used the bullhorn to state, I want all Jen McCabe's neighbors to know, in case they don't already know, the people that live right here, they are cop enders. They are cop enders that live here. He further states, they, the McCabes, will try to live like nothing happened, but we are not going to let them do that because you do not get to end a cop end a police officer and a father's life and get away with it. Carney spent approximately 8 minutes in front of the McCabe residence. So every residence they went to, they spent 10 minutes or less. So the rolling rally is protected speech. It is their right to assemble peacefully, which they did. Just because you don't like the things that he said during the protest doesn't mean that you get to lock him up. All right, so in the days leading up to January 22nd, cameras were placed outside of several of the locations where the protest was scheduled to occur. Sorry. My brain puts words there that aren't there. Or maybe it's my mouth spits them out. I don't know. So all of this is repeated. All of this is repetitive. We read that they said they never met one another. All right, this was, what was it? Witness interference for Matt and Jen McCabe. And then the same one is witness intimidation of a witness and picketing of a witness. And I believe it's all the same. I think it was just a repeat of the other one because it's both Matt and Jen. Yeah. Oh, here. Wait. No, I read that up in the other one. We read all of this. Yeah. So this is all the same. Basically, it was just repetitive because of the two individuals. And they've got conspiracy to commit intimidation of a witness also. So they got them on conspiracy as well. I missed that one. So yeah, there's that. Those are just the original charging documents. So there's also this document that came, when was it filed? I don't have it. This is, why is that date not on here? Maybe it's at the end. This is another document about Aiden's, so November 9th by the Justice of Superior Court. This is the orders that he received November 9th. So he had all those charges he received October 11th. And then by the 9th, this was the order placed by the judge. And I'm going to read through some of it. We're not going to read all of it because a lot of it is repetitive from the other portion. So here, defendant Aiden T. Carney is charged by complaints in the Stoughton District Court with witness intimidation, unlawful picketing to influence a witness, and conspiracy to intimidate a witness. On October 11th, 2023, the District Court released defendant on personal recognizance but ordered him to stay away from and have no contact with the named witnesses and alleged victims. So all of the people that we've talked about, he cannot contact. He could talk about them on a stream, but he cannot contact them. Defendant is now before this court on his petitions under whatever rule that is to vacate the stay away no contact order. He argues that because he is a member of the media, the stay away no contact order is vague, overbroad, and cannot apply to him without running afoul of the First Amendment, and that the statutes under which he is charged do not put him on fair notice of what constitutes criminal behavior. After 2 hearings and after a careful review of the parties' numerous filings, including the parties' post-hearing submissions, I largely disagree for the following reasons. So, Aiden tried to get the stay away order removed or lifted, and this is the court's decision to not lift the stay away order, which I don't understand, but we'll read. All right, so defendant's interest in the case. He's a local blogger, Turtleboy. We don't need to read. We know who Turtleboy is. Trooper Proctor is the lead investigator on the Reed case. Witnesses in the Reed case include Matt McCabe, Jen McCabe, Julie, Colin, Bryan, all those people. We don't need that. All right, so to say that defendant has taken a pro-defense position on the Reed case is to understate the level of his partisanship and advocacy. So what? He can take a pro-defense. The Karen Reed case in Canton, The Killing That Tore the Town Apart, Boston Magazine, available here. All right, so last viewed on that date, which quotes defendant as writing or saying, Karen Reed is a completely innocent woman wrongly charged by corrupt cops who would see her rot in prison in order to cover up a murder of a fellow officer. And about the deceased family, with the O'Keefes, enough of the effing pity party for these people. The only good part about John not being alive is that he doesn't have to be around you useless maggots for a second more. F you, F your high horse, burn in hell. I don't know what that was in context to, but it's still free speech. He can say those things. I don't know. I'm sure he was angry because a lot of the members of Karen Reed's family believe the Commonwealth's theory that Karen hit him. So unfortunately, they haven't looked at the evidence. And once they do look at the evidence, then maybe they can change their minds. I don't know. I think they're being heavily influenced by Jen McCabe and the Alberts, because we've found out that Jen McCabe has been interwoven into Aiden's ex-girlfriend's life, and that's part of how he got the charges and is in prison now. So, as these quotes suggest, defendant prides himself on not being a controversial journalist. According to the Boston Magazine piece, defendant claims that the beauty of Turtleboy is that I can do things in an unconventional manner that other journalists are restricted from doing. I love being the center of attention and being theatrical and performing. This is what I was made to do. How's that not protected? He can do he doesn't have to work for an entity. He can be his own independent investigator. So yes, he can use means that other journalists cannot. He's not stating a lie or anything, he's not misstating facts. In pursuit of his performative journalism and personal brand, defendant has berated witnesses in the Reed case, badgered them although they have indicated that they do not wish to speak to him, and pressured him to change their testimonies. That he never did. Here this says, journalists generally adhere to code of ethics that constrain their behavior. Not necessarily, and you don't have to. Like, this really isn't you don't have to abide by a code of ethics as a journalist. Is it good to do so that you have trusted sources and things like that? Yes, it's good to go about things in a conventional way, but sometimes you have to get answers in an unconventional way. And the people in this case, the witnesses, oops, slip of the tongue, I don't remember. They need to be held accountable is all I'm saying. We need to get this going. Finally. All right, so what did I say? Defendant has been able to increase his following substantially based on monthly page views and viewership with his confrontational stories, live videos, and inflammatory blog posts. So, harassing conduct and telephone calls. The criminal complaint against defendant is in the Stoughton District Court arise out of defendant's actions reaching out to witnesses and their family members, organizing a caravan of vehicles to drive by the homes of witnesses or family members, and posting veiled threats, sarcastic and rhetorical questions, and other harassing information in the course of his, quote, reporting on the Reed case. Okay, I'm sorry you don't like his way of reporting, but he's reporting on the Reed case. He is, whether you like it or not. So these actions are reflected in reports by Massachusetts State Police Detective Lieutenant Brian Tolley. submitted in support of the Stoughton court. So all that statement of facts that we just read, the 70-page document, that is what she's referring to. And then they watched clips at the November 1st hearing, apparently. So I describe only some of the actions by defendant set out in Detective Lieutenant Tully's reports. Defendant has posted a number of YouTube videos in which he issues veiled threats to various witnesses in the Reed case, or encourages his followers to take action with respect to such witnesses. For example, after visiting witnesses' homes in Canton, defendant posted a video online in which he stated, "It might frustrate him to no end because I know Brian Albert is watching this right now. To watch me just emasculate his family time after time, and there's nothing you can do about it. There's nothing you can do. And I'm just going to keep doing it. This is not my last trip to Canton. I will be back." And more, I think people are getting like a year or so ago. I don't know. All right. So what? So what that he said he's going to be back and then he's going to protest you again? I don't think he ever did. He came back to Canton, but they never did a rolling rally like that again. All right. So in the same post, defendant states, "You haven't seen the last of me. These people think I'm effing around. I'm Mr. Internet guy. Like I'm going to sit here and I'm going to write blogs all day. No. I live an hour away. I've got a Lexus now. I'll be there in an hour. No problem. Get used to it." In another video, the defendant states, we read that before, but we did read this quote. So they really don't have that much. They just keep repeating it. So defendant traveled to Canton and went to pizza restaurant owned by Chris Albert. Later, according to Detective Tully, on a video posted on YouTube, defendant encouraged his followers to order food from Chris Albert's restaurant but not pay for it. And I don't recall him saying that. But Chris Albert says that the restaurant had a vast increase of number of phone calls of orders that were not picked up or paid for. Detective Lieutenant Tully indicates that the defendant made other trips to the same restaurant and held signs and confronted people in and around the restaurant. So, it's a public place. In April 2023, defendant started writing blog posts about Trooper Proctor's wife, Elizabeth. On April 17th, 2023, defendant posted on Twitter a statement alleging that Colin Albert is responsible for O'Keefe's unaliving and that Colin and O'Keefe had a fist fight at 34 Fairview Road. Since then, defendant has authored a number of other posts about Colin, his alleged propensity for violence, and personal information, including where Colin will be attending college. We read all that in the statement of facts. According to Detective Lieutenant Tully, in a video posted on May 9th, 2023, defendant displayed Elizabeth Proctor's cell phone number and indicated that both Trooper Proctor and his wife were lowlifes, bullies who terrorized people for years and deserve to lose their jobs. So, all protected. It's all protected. Everything in this document is protected speech. I don't care what you say. After the description that we just read, speech is highly protected. So, I don't know. They'd have to prove that he was defaming them. It would have to be a civil case, not a criminal case, if they wanted to, like the families themselves. This shouldn't be coming from the Commonwealth. It should be coming from families themselves. Like if Jen and McCabe are like, "No, you're defaming us," then they should put up a civil lawsuit about that, which they'll never win because this is all freedom of speech. And they don't have proof to back up that he's lying because he's not. All right, so I don't know where I left off. Defendant publicized the identity of Elizabeth Proctor's employer, which had no involvement in the Reed case, identified her position with that company, and posted the main telephone number for the company. And I know this was in response to Elizabeth Proctor and others trying to get people fired from their jobs. So I know this was in response to that. Not that it makes it right or anything. I'm just saying, like, she did it. So how can she get justice for it happening to her? Like, I don't know. What's good for her is not good for everybody else, I guess. So defendant encouraged his followers to leave a review on the company's open Facebook page or Twitter account. The next day, defendant posted a live. In July... Oh, wait. Do we need to read this? He just warned them, you can leave the country, your life's not normal. Okay. So he posted a live video during which he repeated Elizabeth's cell phone number, called the number, and left a message that contained the following. Hi, Elizabeth. This is Aiden Carney calling you back from Turtleboy. I noticed that your employer took down their social media pages within minutes of the blog I published about your recent behavior, and I just wanted to see, is it awkward? Were you afraid to go in? When we read this already before in the very first charging documents. Because remember, he said, bye, girl. That made me laugh. So I'm not going to read it again. All right. So on June 6, 2023, defendant traveled to Billerica and confronted the McCabe's at a youth sporting event. Defendant later posted videos of the interaction online. Defendant stated in a blog post about the incident that the McCabe's do not deserve to live a normal life and pretend that they weren't involved in the ending of John O'Keefe. So again, they just keep repeating the same stuff. They really don't have anything. On June 13th, defendant broadcast another YouTube video which displayed records from Jen McCabe's phone from the day that O'Keefe was ended, which with names next to the phone numbers. These documents had been in an attachment. We ran through this already. About the message that he left Julie Albert asking if she was pissed that she lost best looking to Jen McCabe. Which is funny. All right. So then on June 19th, 2023, defendant called Chris Albert's phone. When there was no answer, defendant left a voicemail calling Mr. Albert Chicken Parm Charlie and identifying himself as award-winning journalist in Kearney. After asking questions about how long Mr. Albert's family has known Trooper Proctor, the defendant ends the voicemail with the following. So did you guys have both have amnesia on February 10th that you needed to be formally introduced? You often need to be introduced to the people that you have known for a long time. Do you live perpetually in Groundhog Day? I know this is right around Groundhog Day. So remember, we read this earlier. And he wants 2 blackened chicken parms, extra mutts. But I still think this is protected speech. Regardless, if you don't like it, these are good questions to ask. So it's really funny to me that the Commonwealth is just highlighting all the glaring inconsistencies by pointing out the things that Turtleboy is asking. Because by trying to shut Turtleboy down, they're just bringing attention to it by putting it here all out for everyone to see in these documents. It shows what the other side is doing. All right, so on June 26, 2023, defendant went to the McCabe's home in Canton and videotaped, and that was when he saw her through the front door. He also published photographs of one or more of the McCabe's children and a sign that he put on the lawn of Jennifer McCabe's sister, which we read through. The voicemail he left for Colin. A defendant organizes drive-bys of homes, which is not illegal. This is not illegal. I don't know why this is even in here. Defendant organized and publicized the rolling roid. Yeah, this is hard to say. Rolling road rally. Not roids. I don't know. You might want to do roids while you're on a rolling road rally for roids. That's sorry. That's a lot of R's. Okay, so he apparently organized and publicized this rally to bring his followers to the homes of witnesses and the lead investigator in the Reed case. At about noon, the defendant met a number of people in Norwood. He live streamed the vehicle caravan representing up to 200 people. The vehicles first drove to Brian Albert's residence in Norwood. During the video, defendant bragged about being able to locate the witnesses wherever they travel, because I guess they traveled out of town. The second location was the Proctor's home. The Proctors were not home. Defendant stayed at the location for about 7 minutes. During that time, defendant used a megaphone. It stated that Trooper Proctor had framed Karen Reed. Well, so what? That's what he believes, and that's what he wants the world to know. While in front of the Proctor's home, members of the protest, which was organized and fomented. I don't know what that word is. By defendant, walked on the Proctor's lawn and spit on his driveway. So members of the protest, spit on the lawn, but we don't have clips of that. We don't know for sure. The third location, we don't know who was the one spitting. And I think even if someone did spit, I don't know, what does that matter? But is spitting on someone's lawn illegal? Are you not allowed to do that? The third location was the McCabe's home in Canton, where they live with their 4 children. Defendant spent 8 minutes, 8 nights in front of the McCabe house. Ooh, that would be annoying. I wouldn't want to do that. On his video, defendant said that Jennifer McCabe is going to jail, participated in unaliving manufactured evidence, and lied to investigators. Defendant took a bullhorn so that he could be heard by the McCabe's neighbors, stating that, and so what? Stating that that she is a cop ender, that Matt and her are in a conspiracy of a cover-up. So what that he says that? It's not illegal to say these things. The McCabe's are going to try to live like nothing happened, and we're not going to let them do that. Okay, so whatever. You think that's a threat? The rolling rally, I'm just going to say, went to Juliana Nagel's home in Canton. Ms. Nagel was at home. She lives in that home with her parents and 2 siblings. Defendant stopped at Miss Nagel's home for about 10 minutes. At that location, defendant announced that Ms. Nagel lives at the residence, encouraged her to come out and tell the truth, and sought to have Ms. Nagel's neighbors pressure her. Detective Tully quotes defendant as saying, "You might as well tell the truth and let the world know what happened. Neighbors, maybe you guys can help us pressure them into this." Julie Nagel was at the unaliving of a Boston police officer. She knows what happened, and she is actively involved in the cover-up. She should not be able to walk around town like none of this happened while an innocent woman named Karen Reed suffers the consequences of her silence and her complicity. While traveling to the next stop, defendant broadcast that the stop was Ms. Nagel's house was a good one because they were home. So what? Like, I don't understand what you're trying to prove. Even this judge is like caught up in these quotes that are so totally out of context. Other conduct. In and before late September 2023, defendant obtained information about motor vehicle registrations from the Criminal Justice Information Service database from Janelle Webb, a civil dispatcher with the Avon Police Department. Defendant knew or should have known that it is illegal to obtain or to have Ms. Webb obtain such information. On September 25th, 2023, defendant tweeted a photograph and message depicting vehicles parked at the Proctor's home, including information about the vehicle registrations that he improperly obtained from Webb. On September 24th, 2023, defendant broadcast a live YouTube video when talking about an interaction he had with Colin Albert's aunt. Defendant stated, "I'm trying to put her, like godson, nephew, in jail and, kind of like destroy their life." On October 2nd, 2023, defendant posted a video on YouTube. During that video, defendant stated that you, Chris Albert, don't have a right to live peacefully, dude. It's not a thing. Procedural history. On October 11th, 2023, defendant was charged with and arraigned on 9 criminal complaints, each charging one or more of the crimes of witness intimidation in violation of GL 26813B, unlawful picketing in order to influence a witness in violation of 26813A, and conspiracy to commit witness intimidation in violation of 2747. The different criminal complaints involve different alleged victims. So we already went through that. We went through all the charging documents. Also on October 11th, 2023, Judge Daniel O'Malley released defendant on personal recognizance and entered an order in all 9 dockets requiring defendant to stay away from and have no contact with the named witnesses or alleged victims. In his order of pretrial conditions of release, Judge O'Malley placed an X in the box of have no contact, direct or indirect, with circled direct or indirect. What? And wrote to stay away and no contact from each named witness via any mechanism. He also placed an X in the box next to stay distance away from Juliana Albert, Michael Proctor, Jennifer McCabe, Matt McCabe, Chris Albert, Colin Albert, and Elizabeth Proctor. Judge O'Malley did not specify a particular distance defendant had to maintain from the particular witnesses in order to stay. Defendant now appeals the stay away, no contact order in his petition for review of district court bail determination. Defendant argues that all of his actions and statements were done as acts of indisputable journalism and that the district court's order will have a pronounced chilling effect on his ability to continue to cover the story of the Reed case and will constitute a prior restraint on his speech. He's still allowed to write about them, though. He can still write about them and he can still report on them. He's just not allowed to contact them or go near them within, I think, 100 feet or whatever. So he also argues that the stay away, no contact order is vague and essentially gives the 8 individuals veto power over his reporting by allowing them to simply show up at any venue, any public place, any courthouse relevant to his reporting and flush him out, evicting him at will under risk of 90 days incarceration. So that is important. You need to have some kind of limitations on that. So in subsequent filings, defendant argues that the statutes in question are vague as they apply to him. Discussion. Authority to review stay away, no contact order. The district court has statutory authority to issue the stay away, no contact order under Massachusetts law in considering bail if a judge of the district court determines it to be necessary. The judge may order the defendant to abide by specified restrictions on personal associations or conduct, including but not limited to avoiding all contact with an alleged victim of the crime and any potential witness or witnesses who may testify concerning the offense as a condition of release. So there you have that. In contrast to conditions imposed under 27687, which require the defendant consent, 27658 expressly authorizes a judicial officer setting bail to also include a stay away, no contact order, even over defense's objection. So she's saying she has to do it even over his objection for some reason. I don't know why. If any lawyers in the chat know, or anyone with legal understanding of why they would have to still include a stay away order, let me know in the comments below, please. All right, so the parties agree that the Superior Court has the power to review the conditions set by the District Court. The Superior Court shall, in accordance with the standards set forth in the first paragraph of this section, hear the petition for review. The Justice of the Superior Court may, after a hearing on the petition for review, make any other order of bail or recognizance or remand the petitioner in accordance with the terms of the process by which he was ordered committed by the district court. So they're saying basically the Superior Court has authority. Rather than challenge the district court's legal authority to issue the stay away, no contact order, defendant challenges the factual basis for the charges against him, particularly the charges of witness intimidation and unlawful picketing. Detective Lieutenant Tully's reports, which provide excerpts from recordings later submitted to this court on a thumb drive, demonstrate more than sufficient evidence to support the criminal complaints, which I absolutely disagree. If you ever watch the show, you would, well, obviously this judge doesn't watch the show and doesn't understand things being taken out of context. Massachusetts law makes it a crime to threaten physical, emotional, or economic injury or to harass a witness or a witness's family in reckless regard of the fact that it may interfere with a criminal case. Our law also bears retaliation against a witness for participating in a criminal case. The relevant provision states, whoever willfully, either directly or indirectly, threatens, attempts, or causes physical, emotional, or economic injury to or harasses another person who is a witness, a potential witness, or officer, or a family member of such person with the intent to or with reckless regard for the fact that it may, 1, impede, obstruct, delay, prevent, or otherwise interfere with criminal investigation. So, we read that before, and that is basically the statute that is illegal because having a protected type of person who you can't say things to is kind of against the Constitution. Oh, that quote went on. But anyways. All right, so for purposes of this statute, the term harass is defined as any act directed at a specific person or group of persons that seriously alarms or annoys such person or group of persons and would cause a reasonable person or group of persons to suffer substantial emotional distress. For defendant, a violation of 13B is punishable up to 20 years in state prison or 2.5 years in the House of Corrections, because the proceeding in which the misconduct is directed at involves the investigation or prosecution of a crime punishable by life imprisonment. However, if the federal grand jury comes about, or not the federal grand jury, the feds, the FBI comes out and starts making arrests in the Karen Rean case regarding the investigators and the corrupt law enforcement and government representatives that we have over in Norfolk District County, those people are possibly going to be charged with crimes of covering up crime, framing Karen Rean, all of the above, all of the things that Turtleboy is saying that he's in prison for. These things are going to happen, and when they happen, they're no longer witnesses. So hopefully all of this gets thrown out because he's no longer threatening a witness. But even so, this particular statute is unconstitutional in and of itself, but just because of him not being able to picket people. All right, so where were we? For defendant, a violation of that. Oh, we read that. Okay, life imprisonment, right? Yeah, so he could go to prison for this. This is crazy that he could go to prison for this. That's how badly they want to shut him up. Detective Lieutenant Tully's reports demonstrate a concerted effort and repeated pattern of conduct designed by defendant to cause or threaten economic or emotional injury to witnesses or family members of witnesses and to harass those witnesses to get them to change their testimony. Defendant's actions in soliciting his followers to contact Elizabeth Proctor's employer, to order food from Chris Albert's restaurant and not pick it up for pay, and to contact the college Colin Albert attended or planned to attend were all designed to and did inflict economic and emotional injury. I disagree with that, but okay. Defendant's efforts to persuade neighbors of I disagree with the charges or the allegations, however, because I don't think that he was willfully trying to, willfully threaten or attempt physical, emotional, or economic injury. And we know that they lied in portions of their statements here, so. Where did I leave off? Defendant's actions in soliciting his followers to contact Elizabeth Proctor's employer to order food from Chris's restaurant, not pick it up, all designed to and did inflict economic or emotional injury. Defendant's efforts to persuade neighbors of the McCabe's and Juliana Nagel to pressure the witnesses to change their testimony. They're not asking them to change their testimony. They're asking them to come out and say the truth. Tell us what really happened that night, because we know we don't have the truth. The numerous calls, contacts, voicemails, and the like reflect a systematic pattern of harassment designed to intimidate the witnesses. I don't agree with that. I believe he only called each of them like once or twice maybe, and just because he did it on the show doesn't mean that it's a repetitive thing. I don't know. Citing Bryan versus Borowski, defendant argues that the witness intimidation statute should not apply because he engaged in protected speech under the First Amendment. O'Brien does not go nearly so far. The First Amendment does not authorize journalists to commit crimes. He didn't commit any crimes. In O'Brien, the court considered a petition for relief from a stay-away order under the Civil Anti-Harassment Statute 285E. The court held that the definition of harassment in that statute excludes constitutionally protected speech, and that the phrase intent to cause fear in the definition of harassment is limited to fear of physical harm or physical damage to property. Assuming without deciding that the same limits apply to the witness intimidation statute, O'Brien still does not aid the defendant's argument. The charges against defendant do not stem from his speech alone, but also his conduct, which is not protected by the First Amendment. Baloney! What conduct? Moreover, just because you don't like it, Judge, doesn't mean that it's illegal. Moreover, speech such as, I'm going to find you, you want to effing dance, and we'll F any of you dogs up. That was from Colin. Colin said that. And defendant's speech designed to exhort his followers to engage in threatening or harassing conduct, which he never did, are true threats that are not protected by the First Amendment. He never did. True threats are words that are intended to place the target of the threat in fear, whether the threat is veiled or explicit. Defendant supplies no authority for his argument that the witness intimidation statute does not apply to journalists. Defendant is also charged under 26813A for having picketed or paraded near witnesses' homes with the intent of influencing the witnesses. No, not to influence them, to get them to tell the truth. Section 13A states, whoever with the intent of influencing any witnesses in the discharge of his duty pickets or parades in or near a residence occupied or used by such witness commits a crime punishable by imprisonment for or up to a year. Well, that's great, but he didn't try to influence a witness, and this would be illegal, not allowing people to picket or parade near someone's house. That's not a crime. So according to Detective Lieutenant Tully's report, defendant organized and orchestrated a rolling road rally, I got it that time, to go to the residences of the witnesses. During the rally, which involved a caravan of vehicles and by defendant's estimate at least 100 people, defendant used a bullhorn to accuse Trooper Proctor of framing Reed. And announced personal information about Trooper Proctor's family to inform the McCabe's neighbors that they were cop enders and to recruit them not to let the McCabe's live like nothing happened, and to pursue Juliana Nagel's neighbors to get her to tell the truth about the cover-up. Such actions demonstrate an intent to influence and pressure the witnesses to alter their testimony. Is it altering their testimony if their first testimony was a lie? Is it altering? I mean, tell me. Is it altering your testimony if your first testimony was a lie and he's trying to get you to tell the truth? Is it influencing and altering? I don't know. I don't think so. I think it is I think it's within his right to tell people to tell the truth. Given the existence of probable cause to believe the defendant committed at least some of the offenses with which he is charged, the district court has the authority to impose a stay-away order. Constitutional guarantees of free speech and free press. Lawful news gathering and news reporting is protected under First Amendment of the United States Constitution. It is also protected by Art 16 of the Massachusetts Declaration of the Rights. The liberty of the press is essential to the security of freedom in a state. It ought not, therefore, be restrained in this Commonwealth. The right of free speech shall not be abridged. I agree with all of that. The constitutional guarantees of free speech and free press, however, do not protect advocacy that is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. That's not true. I thought that was the exact opposite of what that Constitution, whatchamacallit, states. That activism is protected because it would be under, I don't know, maybe it didn't say. It wasn't even listed as one of the low speeches. Threats and fighting words and defamation, obscenities, and he didn't do any of that. I mean, yes, he did do that, but it's still, whoops, oh no, I went back to my mail. You guys don't need to see my mailbox. All right. Anyways, I thought that advocacy was protected. Journalist actions are also circumscribed by the criminal law, at least to the extent to applicable criminal statutes, like those at issue in this case, are not solely directed at the free flow of information. The freedom to gather information guaranteed by this First Amendment is the freedom to gather information subject to the general and incidental burdens that arise from good faith enforcement of otherwise valid criminal and civil laws that are not themselves solely directed at curtailing the free flow of information. So yeah, why are you curtailing the free flow of information by stopping him from doing his job? In addition, courts have an obligation to protect the integrity of the judicial process and may take such steps by rule and regulation that will protect its processes from prejudicial outside interferences. How is he an outside? I don't know. Although litigants do not surrender their First Amendment rights at the courthouse door, those rights may be subordinated to other interests that arise in this setting. For instance, on several occasions, the court has approved restriction on the communications of trial participants where necessary to ensure a fair trial for a criminal defendant. In the conduct of a case, a court often finds it necessary to restrict the free expression of participants, including counsel, witnesses, and jurors. Internal quotations and citations omitted. Okay, that's fine, but that's like if you have a gag order. You can't put a gag on the press. If you want to gag the information, you put a gag on your counsel, your attorneys. You gag the people that are involved in the process, not the people that are reporting on it. So notwithstanding defendants' unusual tactics and inflammatory rhetoric, I assume for purposes of this decision that defendant is a member of the press who, among other things, is covering a pending murder case. He claims that because he is a member of the press, it is a violation of his First Amendment rights and Art 16 of the Massachusetts Declaration of Rights to require him to stay away and have no contact with witnesses. Journalism generally involves eliciting information from sources who may be witnesses in a case, not attempting to have witnesses change their testimony or inciting others to pressure witnesses to change their testimony. Defendant had no license in the name of journalism has no license in the name of journalism to intimidate or harass witnesses and jeopardize the integrity of judicial proceedings. You don't need a formal license to be a journalist. You can be an independent journalist. You don't need to be licensed for it. For another citizen, such actions would not be tolerated. Baloney. If you're reporting on a case, this whole thing makes me so angry. Sorry. All right, so notwithstanding the fundamental importance of news gathering and reporting, the First Amendment does not supersede the proper administration of justice and the court's obligation to ensure a fair trial, including protecting witnesses from intimidation. The purpose of witness intimidation statute is to protect witnesses from being bullied or harried so that they do not become reluctant to testify or to give truthful evidence in investigatory or judicial proceedings, and to prevent interference with the administration of justice. The right to a fair trial is just as important to the functioning of democracy as the First Amendment. Agreed. However, what he is doing is not trying to change someone's testimony into, intimidation of a witness for witness testimony is usually like, I'm a witness to a crime. I saw a crime and the killer or whoever, the bad guy saw me see it, and now he wants to get me because I want to testify against him. So that's what the statute is for. So he can't like come after me and tell me like, hey, don't he can't try to change my testimony if I were to go to court and testify against him. He can't bully me out of going to tell the truth. Telling the truth, why can't you try to convince people to tell the truth, to tell to not lie in the court of law, or when you are when you're giving your statements to law enforcement? Who's keeping the witnesses accountable for their statements? That I don't know. And who says that they're witnesses also is my big question, because they were cleared early on. Like, they were never even questioned as suspects. Anyways, so due process, right to fair notice of crime. Defendant argues that the witness intimidation and anti-picketing statutes are vague and shouldn't apply to him. A basic tenet of due process requires that a criminal statute be sufficiently clear to give notice of the prohibited conduct. So that's right. I mean, it's very vague, and it mentions everyone and their mother, family members of a witness, and, law enforcement and everyone involved. So I don't know. A statute violates due process and is void for vagueness when individuals of normal intelligence must guess at the statute's meaning and may differ as to its application, thus denying them fair notice of the prescribed conduct. The underlying principle is that no man shall be held criminally responsible for conduct which he could not reasonably understand to be proscribed. So if you can't understand the statute, then you can't be held by that statute, is what that's saying. So penal statutes must define the criminal offense with sufficient definitiveness that ordinary people can understand what conduct is prohibited. Internal quotations and citations omitted. All right. Defendant asserts that the stay away contact order should be stricken because of whatever statutes did not put him on fair notice that his conduct, which he describes as normal journalistic tactics, was criminal. I am not persuaded by this argument. The words of the statute are commonly accepted and understood, and the term harass is sufficiently defined under whatever statute to put an individual on notice of the proscribed conduct. See McGee versus Mass, whatever. The language in the statute will be constitutionally adequate if it conveys sufficiently definite warning as to the proscribed conduct when measured by common understanding and practice. The dearth of cases charging journalists with such crimes shall not compel a conclusion on that statute is vague, particularly where defendants' tactics are previously described cannot properly be classified as typical behavior for a journalist. What is typical behavior? You guys don't know what typical behavior of a journalist is. You don't see everything that they do to get their stories. There isn't necessarily a code of conduct that they must abide by, or like some code, some secret journalism code. There is evidence here that defendants' statements and actions may intimidate witnesses involving in the Reed case and threaten the integrity of the proceedings in the case. The language in the first paragraph permitting a judge to institute a stay-away order as a condition of release clearly contemplates that limits may be placed on the defendant's contact with an alleged victim, as well as the other witnesses, presumably for the purpose of preserving the integrity of the judicial process. The general stay-away, no-contact orders here are justified to protect the witnesses and the judicial process. In certain respects, however, the district court's order is ambiguous. First, by not including a distance in connection with the stay-away order, the district court did not provide defendant with sufficient information so that he could conform his conduct in the court's order. So I will amend the conditions to require defendant to stay away at least 100 feet from the witnesses. Second, the district court's order of pretrial conditions of release does not reflect consideration of defendant's interest in reporting on the Reed case and whether there are other less restrictive alternatives to allow defendant access to court proceedings attended by the alleged victims or witnesses in the Stoughton District Court matters. Here, defendant has a journalistic interest in reporting on the Reed case, which should be able to be accommodated by the court's officers in the controlled environment of the courthouse. In the mine run of domestic violence cases in which one party to the case is ordered to stay a specific or specified distance away from the other party, often 50 yards or 100 yards, both parties are permitted to attend their common court proceedings even though it will bring them into closer proximity than is specified in the stay-away order. This case is no different. Provided defendant complies with the rules of the court, defendant will be permitted to attend proceedings in the Reed case, even if victims or witnesses in the Stoughton matters are in attendance. So there you have it. He can still go to court proceedings on Karen Reed, even if any of his witnesses that he's supposedly harassing are there. As ordered by this judge, defendant's petition for review of the Stoughton District Court stay-away no-contact order is denied. As to the no-contact order, and is denied as to the stay-away order, except that the stay-away order is amended to require defendant to stay away 100 feet. And that was from Judge Krupp, Peter Krupp. So he's been going like around, and that was Superior Court. But then, as we know, later all of these charges were amended in Superior Court and thrown out, basically. So we are going to probably end here. I do want to go through some of his posts here to kind of discount the charges, though. So there were 13 counts initially charged in Stoughton District Court with 13 counts, including 8 witness intimidation charges. This is Turtleboy's blog. This is his words. 1 conspiracy to commit witness intimidation and 4 picketing of a witness charges. The 3 new counts appear to be 2 conspiracy to commit witness intimidation charges and 1 new picketing of a witness charge. So remember, he got charged again. He got more charges added on, and he says it's not clear what those are yet, but he thinks it was for Brian Albert's house because it was in Dedham District Court and not Stoughton. So that, I believe that's what it was. this is what Turtleboy said. I knew this day would be coming and always assumed I would be indicted. But let me be clear, I am not deterred in the least. I will not give in, I will not surrender, and I will never plead. I will fight these charges. I will be victorious, and it will go down in the history of books as the greatest defense of the First Amendment in the history of journalism. So there you have it. He is definitely fighting these charges. He feels these charges are unfair, unwarranted. Everything was taken out of context, so he's fighting this, and I think he should. Let's be clear about what is happening here. They are doing this because my reporting on the Karen Read case has been far too effective at exposing corruption in the Norfolk District Attorney's Office and the Massachusetts State Police. They want to silence me, so I can't point out that John O'Keefe's injuries clearly did not come from being hit by Karen Read's otherwise fully intact Lexus SUV. And I'm going to give you a trigger warning because we're going to see John's injuries again. So trigger warning. I'm going to go through it real quick. Here is a picture that Turtleboy posted on his blog. He said, "What really happened? They want you to believe that all these injuries from John O'Keefe, his bruised hand, his black eyes, his gash on the back of his head, they want you to believe that it was all done by this little piece of taillight, basically, because that's the only damage on her car." Yeah, so they wanted to indict me before Christmas because Karen Read's trial date is less than 3 months away, and they know that they are going to be badly exposed when that happens. They know that Michael Proctor, Brian Tully, Yuri Buchanan, and the 8 alleged victims of witness intimidation will all have to take the stand at her trial. I would love to see Alan Jackson and David Yannetti rip all of them apart in a trial. That would be so entertaining to have them rip apart their testimony and break apart their lies. But I don't think it's going to go to trial. I think the feds are closing in the next couple of weeks, but we shall see, because her trial is supposed to be March 12th. So we're almost like a month away. And all this is still happening. So anyways, when they do that, they will be exposed as perpetrators of a conspiracy to cover up murder. Every question I ask them and every statement I have made about them, which has been mischaracterized as witness intimidation, will be shown to be legitimate reporting on corrupt criminals. My interview of Gemma Cabe in Billerica last June is the perfect example of that. He gives you the link. Just a reminder, the same DA's office that issued these indictments to me today is currently under investigation by the U.S. Attorney's Office for Corruption. I am not under investigation by the USAO. I am not the least bit worried, but I would be if I were them. Superior Court juries consist of 12 people instead of 6, and they will never find 12 people who they can convince that asking questions to people who covered up unaliving is a felony. The best way you can fight back against these criminals is to donate to Turtleboy. He has on his blogs and his website, you can go donate to him. He's got like a PayPal or Cash App or whatever. He's got that too you can use. So that's a good portion of where we are today. But since then, we know that his charges were dropped in Superior Court. So I'm just going to give you a little recap. Back in December, it was dropped in Superior Court, his stay away orders. But then they got him on this bogus DV and assault and battery charge that they have against his ex-girlfriend, and that's going to be he needs to go to court for that now. But there was a hearing for it, and we found out she's a big liar, and the judge extended a stay away order for a year for Aiden, so he can't see his ex-girlfriend for a year, and I'm sure he's pretty happy about that because she crazy. Next time I want to go through this blog post from Turtleboy where he kind of goes through some of the things that were said in the statement of facts, and then he discounts it or tells why, they're taking it out of context. So that'll be our next topic. And I also want to do, since he's been in prison, he's been doing like turtle diaries. So I'm going to do an episode on the turtle diaries too when I'm ready to do that one. I think I'm trying to figure out how to do the next couple of episodes because there's a lot of Turtleboy content to cover. I'm trying to figure out the best ways to organize it and get it together. So I'll let you guys know for sure what will be next. But we're going to keep going on Turtleboy because there's still a lot here. So with that, please let me know what you think about this case. Let me know what questions you have about this case. I would love to, engage and research. If you have questions about certain things, I can always go and find it in the documents that I have. So let me know what you guys think. What do you think of Turtleboy being in jail? Do you think they should let him out? Do you think he's exactly where he should be? Let me know in the comments below. Please be sure to like, comment, and subscribe, and I'll see you next time. Bye.